the Simpson matter, all parties are again present. Jury is not present. Record should reflect that over the noon hour, we had an informal showing of the argument boards produced by the defense. Counsel, any comment before we resume with the jury?
Yes, Your Honor. We had a couple of objections to lodge.
Ms. Clark.
We filed with the court a couple of motions. One dealt with the potential for Mr. Cochran to mention either Detective Furman's invocation, the other, and with the potential for referral to matters contained on the tapes that were deemed inadmissible by this court. And we have proposed a remedy should such violation occur. And the defense response doesn't appear to be very responsive to the people's motion. So the people would urge the court to instruct counsel that if he does violate the court's order by mentioning Detective Furman's invocation, or if he does violate the court's ruling with respect to the content of the tapes that was deemed inadmissible by referring to them in some manner in closing argument, that the appropriate sanction, and one that would prevent, that would make his violation not worthwhile, not worth doing, is to say, if you do mention such a thing, this is the remedy. I will instruct the jury that Detective Furman did not plant the glove. The remedy has to be something that makes it unworthwhile for the defense to violate the court's order. Otherwise, if all it is a monetary sanction or an admonition that it's improper in front of the jury, that would not give the defense incentive to abide by the court's ruling. And so the people urge the court to make sure that the defense does not violate rulings by making a sanction onerous enough so that it would not be worth their while to do so. With respect to the burden of proof chart, does the court want to hear that now?
Yes.
We filed the motion. Did the court have an opportunity to read our motion on it?
No, I have not seen that.
I think
Do you have that chart handy?
I do. Do you have an extra copy there? Did Mr. Robertson give it to you?
Yes.
Okay.
The board room?
Yes. Ms. Clark.
Okay. The problem with this board is that it's extremely misleading, and it's going to confuse and mislead the jury on a matter of law. And it's one thing to draw reasonable inferences from the record and from testimony to say, we've heard this, therefore that. But there is no misinterpretation of the law that is permitted. And counsel, although counsel can ask the jury to draw unreasonable inferences from the record, and that is what he will do, I do not think there's any authority permitting counsel to ask the jury to misinterpret the law, which is what this invites them to do. By creating the impression that the burden of proof is so overwhelming, it would be unbelievable that we could get a conviction in any case if it were as stated on this chart. It's misleading in 5 ways. First of all, it contains phrases, several of them, that supposedly describe thresholds of evidence that don't exist and have never been a part of the definition of reasonable doubt. It contains the phrases highly unlikely, less than likely, probably not, unlikely, and a variety of others, as the court has seen. All of these are used to describe thresholds of evidence that fall into the category of not guilty according to the chart, but none of them find their way into the Penal Code Section 1096 definition of reasonable doubt. So it's misleading in that respect. Secondly, it's misleading because it contains terms in the not guilty range that are consistent with guilty. For example, the phrase may not be is used to describe a threshold of evidence in the category not guilty, when in fact under 290, the jury is entitled to convict the defendant if all they have is some possible doubt. Excuse me. And as the court knows, I did go over with the jury at some length the fact that a mere possible or imaginary doubt is not sufficient to raise a reasonable doubt. What this chart conveys to the jury is that mere possible doubt is sufficient. It contravenes the burden of proof by saying that certain terms, in certain of its terminologies and some of those levels, what they say is a not guilty is actually a guilty. Do you see what I mean? Mm-hmm. So, third, it's also misleading because it implies that proof beyond a reasonable doubt is absolute doubt. I mean, absolute certainty. In other words, no doubt at all. It does that by implication, by having at the bottom of it not guilty or absolutely not guilty, creating the impression that the top of that, which is the burden of proof we have to carry, is absolute certainty. There's nothing in this world that could be proven with absolute certainty. That's why we have proof beyond a reasonable doubt as a standard. Yet by implication, that is what the chart seems to infer to the jury, and that's a direct misinterpretation of the law. Fourth, it's misleading because it uses terms that are synonymous, treating them like they're distinct categories. For example, the terms probably not, less than likely, unlikely, they're synonymous, but they're, in this chart, broken down as though they're separate gradations, when in fact they're all the same. Same thing with perhaps and suspected. So they create gradations that really don't exist. It's a figmentary kind of depiction of all of the levels that a person might have of belief. And so it amplifies the burden of proof unfairly. Fifth and last, the chart is misleading because the visual nature of the representation of the degrees of proof suggests incorrect and unsubstantiated numerical levels of certainty. It would imply that there is some kind of numerical level that could be attached to what constitutes guilt beyond a reasonable doubt. And the inference drawn here by the number of levels that they have, if you work it out mathematically, is that 93% equals guilt beyond a reasonable doubt. That's improper. And we don't categorize our burden of proof by mathematical probabilities or by quantities that can be mathematically defined. That would be impossible to do. It's misleading to the jury, and it's improper. So we would ask the court, urge the court strenuously not to permit this chart, as the jury will be misled as to what the people's burden of proof really is and as to what is meant by proof beyond a reasonable doubt. And then Mr. Mavis points out correctly, as we cited at the end of the motion, Your Honor, the Freeman case makes it very, very clear that to vary from the standard reasonable doubt instruction is a perilous exercise. And this chart varies substantially from the definition given to the jury in their jury instruction and from the definition given in Penal Code Section 1096. And for all of these reasons, because it is misleading, and because it is a very dangerous practice, and because it may very well give the jury a misimpression of what the burden of proof really is, it should not be allowed. Counsel's also previewed for us the laser shows they intend to play. What counsel has attempted to do is subvert the court's ruling concerning the video clips by using stills from videotape. And I thought the court said we couldn't do that. And yet that's what they've done. So instead of playing the moving picture, they took the video clip and just used a still from that.
My recollection, though, is that the prosecution array that was displayed to us also included static photos of persons while testifying.
Well, I thought that we were precluded from using them.
Not the static photos, no.
Oh, I didn't know that.
Yeah. It's the actual use of the videotapes. But if you want to say, this is so-and-so, this is what the person, this is who it is, this is what they testified to, that's permissible.
Oh. Okay.
All right.
Never mind.
Okay.
With respect to the There's one other thing, Your Honor. They showed stills of the glove demonstration with Mr. Simpson, a number of them, with him trying on the gloves in front of the jury. But there's a number of them, which is, in effect, using a video clip. Now, if they want to use that, and if the court wants to permit them to use that, then we would ask the court, in fairness, to allow us to play the whole tape, rather than just those segments being shown by the defense.
Okay. All right, Mr. Blasier, are you handling this matter?
I am, Your Honor. Let me.
All right, good afternoon.
Good afternoon. With respect to the, I guess it's a prophylactic instruction that they want. In case we do something wrong, then this is what our punishment's going to be. I've never heard of anything like that. We know what the rules are. We know what we can say and what we can't say. And I'm sure that if we say something we're not supposed to say, they'll jump up and you'll holler at us, and whatever will happen will happen. I think it's absolutely ludicrous for us to sit here and debate whether we might do something wrong, and if we do, what should happen about it. So I think that's just a foolish motion, quite frankly. As to the charts, the burden of proof chart, I've probably used that chart in every trial I've done in the last 5 years. It's never been excluded. I've never been told by a court that I can't tell the jury what I think reasonable doubt is. They were allowed to tell the jury what they think reasonable doubt is. That's part of argument. That's what argument is for. The court reads the instruction. Those are the words of the instruction. We're entitled to say, this is how we think you should interpret that. There's nothing on there about percentages. I guess they went so far as to count up the little boxes and add them all together and divide up and say that we were going to make some argument that 93% or 7%, I guess, is reasonable doubt. That's foolish. We're not going to offer any kind of a statement like that. The Freeman case talks about the court's instruction. For the last 5 years, I've also asked the court to give my own instructions on reasonable doubt, and I never get those. You always give 2.90. But I've never been precluded from saying, this is what we think reasonable doubt is. They're going to have another shot at the jury. They can get up and say, that's a lot of hooey. You shouldn't look at it that way. You should look at it this way. So I think there's nothing wrong with that chart. As to the video clips, if they want us to show the whole thing, we'll be happy to, at the glove demo.
All right, when we're talking about the glove demo, if both sides want to use that,
Well, no, it's not a matter that we want to use it. It's a matter that I don't think it should be allowed for either side. And what I was saying is that, they have some stills that they want to show, which are, of course, just the parts that are most favorable to them, but I think that it would be inappropriate for either side. We could have used it in our opening argument. That was the plan that we had until it was ruled that we couldn't. But the problem with the glove demonstration is that it's an active, mobile thing, and to take still shots from that is very misleading to the jury, and it has penalized the people because we felt we couldn't use it.
well, my recollection is that the prosecution argued against the use of videotape because it's not the official record.
That's right.
Right.
That's right. And our position hasn't changed, Your Honor. I think the court's ruling was also that we could only, at the point that the court was saying we could use videotape, the court was saying that it could only be tape of the witness in the blue chair, and this doesn't qualify.
Well, this is not a tape of testimony. This is a picture of the demonstrative demonstration that was done. And we only had 2 stills, by the way.
When do you anticipate getting to that?
Yeah, a minute. Hour and a half.
All right, let me see it. Let me see the excerpt that you propose to use. Or the stills, I'm sorry, that you propose to use.
Stills?
Yeah. Submitted.
Both photos? The only point I wanted to add, Your Honor, other than the fact that we would have used this ourselves in opening argument, is that if these photographs are misleading because they only show a portion of it, but in order to show all of, I mean, either the clip should be shown or none of it should be shown, and I think that none of it should be shown. Counsel can argue it as we argued it, but I don't think that this is appropriate, and certainly not the stills that they're using.
All right. Thank you, counsel. All right, as far as the prosecution motion for preemptive instruction, admonition, or warning to the defense regarding Detective Furman and regarding the McKinney tapes, the court finds that to be premature. I trust that counsel know what the law is regarding appropriate argument by counsel. The evidence code is clear that the counsel may not argue or mention the invocation, and I'm sure defense counsel know that the sanction will be swift and severe, and I don't think it's necessary for the court to take any action at this time. As far as the chart regarding burden of proof, reasonable doubt, that is a very familiar chart to the court. I've seen it before. I'm sure I'll see it again. The objection to that is overruled. The objection to the clips of the glove demo is sustained. It is not part of the official record. All right, anything else? Are we ready? All right, Deputy Tarrant, let's have the jurors, please.
Schedule.
3:15? 3:15, and we're going to quit at 7:45 tonight.
And then it'll be a 5 to 6.
5 to 6 break. Go to 7:45. Sure, Ms. Clark. All right, the record should reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. And as I mentioned to you, we had some preliminary matters we had to take up out of your presence. We're now ready to proceed with the defense argument. Mr. Cochran.
Thank you
You
very
may
kindly.
proceed.
Judge Ito, my colleagues on the defense, my colleagues in the prosecution, the Goldman family, the Brown family, to the Simpson family. Good afternoon, ladies and gentlemen. The defendant, Mr. Orenthal James Simpson, is now afforded an opportunity to argue the case, if you will, But I'm not going to argue with you, ladies and gentlemen. What I'm going to do is to try and discuss the reasonable inferences which I feel can be drawn from this evidence. At the outset, let me join with the others in thanking you for the service that you've rendered. You are truly a marvelous jury, the longest serving jury in Los Angeles County, perhaps the most patient and healthy jury we've ever seen. I hope that your health and your good health continues. We met approximately 1 year and 1 day ago on September 26, 1994. I guess we've been together longer than some relationships, as it were. But we've had a unique relationship in this matter in that you've been the judges of the facts. We have been advocates on both sides. The judge has been the judge of the law. We all understand our various roles in this endeavor that I'm going to call a journey toward justice. That's what we're going to be talking about this afternoon as I seek to address you. The final test of your service as jurors will not lie in the fact that you've stayed here more than a year, but will lie in the quality of the verdict that you render and whether or not that verdict bespeaks justice as we move towards justice. Now, you'll recall during a process called voir dire examination, each of you were thoroughly questioned by the lawyers. You probably thought, gee, I wish they'd leave me alone. But you understood, I'm sure, that this is very serious business. Our client, Mr. Orenthal James Simpson, is on trial for his life. And so we had to be very, very careful, both sides, in trying to get people who could be fair to both sides. You'll recall those questions, that you keep an open mind, which I hope you still have even to this day, that you wouldn't be swayed by sympathy for or passion against either side in this case, that you would give both sides of this lawsuit the benefit of your individual opinion. No one can tell you what the facts are. That's going to be your job to determine. It's not a question of age or experience. We talked about that. This is one of those jobs where you kind of learn on the job. And so it's important that you fully understand that. And that's why voir dire was so very important, as we ask you all of those questions before you were sequestered, before you were actually picked. Now, each of you filled out the questionnaire, and you answered the questions honestly, I'm sure. Now, Cicero said a long time ago that he who violates his oath profanes the divinity of faith itself. And of course, both sides of this lawsuit have faith that you live up to your promises. And I'm sure you'll do that. You know, Abraham Lincoln said that jury service is the highest act of citizenship. So if it's any consolation to you, you've been involved in that very highest act of citizenship. And so again, we applaud you and we thank you as we move toward justice. One other entity or group of ladies, or two ladies that I should thank, are our marvelous court reporters. They have been patient with us. They've been here from the very beginning. We very much appreciate them and their services, and I especially appreciate them because sometimes I speak rather rapidly, and they have a tough time keeping up with me. So I trust that today, if I start to speak too fast in my zeal, Ms. Moxham and Chris will bring that to my attention. I'm sure they will. Now, in the course of this process where we're discussing the reasonable inferences of the evidence, I ask you to remember that we're all advocates. We're all officers of this court. I will recall the evidence and speak about the evidence. Should I misstate that evidence, please don't hold that against Mr. Simpson. I will never intentionally do that. In fact, I think you'll find that during my presentation, unlike my learned colleagues on the other side, I'm going to read you testimony, what the witnesses actually said, so there'll be no misunderstanding about what was said about certain key things. But remember that we're all advocates. And I think it was Ms. Clark who said, saying it so doesn't make it so. I think that applies very much to their arguments. Ultimately, it's what you determine to be the facts. It's what's going to be important. And all of us will live with that. You are empowered to do justice. You are empowered to ensure that this great system of ours works. Listen for a moment, will you, please? One of my favorite people in history is the great Frederick Douglass. He said shortly after the slaves were freed, quote, "In a composite nation like ours, as before the law, there should be no rich, no poor, no high, no low, no white, no black, but common country, common citizenship, equal rights, and a common destiny." This marvelous statement was made more than 100 years ago. It's an ideal worth striving for, and one that we still strive for. We haven't reached this goal yet, but certainly in this great country of ours, we're trying. With a jury such as this, we hope we can do that in this particular case. Now, in this case, you're aware that we represent Mr. Orenthal James Simpson. The prosecution never calls him Mr. Orenthal James Simpson. They call him defendant. I want to tell you right at the outset that Orenthal James Simpson, like all defendants, is presumed to be innocent. He's entitled to the same dignity and respect as all the rest of us. As he sits over there now, he's cloaked in a presumption of innocence. You will determine the facts of whether or not he's set free to walk out those doors or whether he spends the rest of his life in prison. But he's Orenthal James Simpson. He's not just the defendant. And we on the defense are proud, consider it a privilege to have been part of representing him in this exercise and this journey toward justice. Make no mistake about it. Finally, I apologize to you for the length that this journey has taken. But you know, when you're seeking justice, there are no shortcuts. If you were to trade places with either side, you'd want someone who'd fight hard for you and vigorously, especially who was a person who had maintained their innocence from the very beginning of the proceedings. Some of you in voir dire talked about that you've been involved in other cases where you felt the lawyers didn't stand up. Well, I certainly hope that in this case, on both sides, you felt the lawyers did their best to represent their respective positions, and we will continue, I'm sure, to do that, so that, although I apologize for the length of the trial, I hope and I trust that you will understand that in a journey toward justice, there is no shortcut. Finally, with regard to your responsibilities, we ask you at the very beginning to don't compromise. This is not a case for the timid or the weak of heart. This is not a case for the naive. This is a case for courageous citizens who believe in the Constitution. And while I'm talking about the Constitution, think with me for a moment. How many times you heard my learned adversaries say, the defense didn't prove, the defense didn't do this, the defense didn't do that. Remember, back in voir dire, what did the judge tell us? Judge Ito said the defense could sit here and do absolutely nothing. One of you is from Missouri, and he reminded you, who's from Missouri here? Say to the prosecution, you show us. Now, we didn't do that. But we don't have an obligation, as you'll see You've heard from the jury's instructions, and at the end I will show you some others. We don't have to do anything. We don't have to prove anything. This is the prosecution's burden. And we can't let them turn the Constitution on its head. We can't let them get away from their burden. My job, one of my jobs, is to remind you of that and to remind them of that that's their burden. They must prove Mr. Simpson guilty beyond a reasonable doubt and to a moral certainty, and we will talk about what a reasonable doubt means. And so now, as we have this opportunity to analyze the facts of the case, I agree with one thing that Mr. Darden said. To this task, I ask you to bring your common sense. Collectively, the 14 of you have more than 500 years of experience. I know you're all young, but you multiply by 14, you won't hold that against me, I don't think. 500 years of experience. You didn't leave your common sense out in that hallway when you came in here. And we're going to ask you to apply it to the facts of this case. I'd like to comment and to compliment Ms. Clark and Mr. Darden on what I thought were fine arguments yesterday. I don't agree with much of what they said, but I listened intently, as I hope you'll do with me. And together, hopefully, these discussions are going to be helpful to you in trying to arrive at a decision. In this case, where you don't compromise, where you don't do violence to your conscience, but you do the right thing. And you are the ones who are empowered to determine what is the right thing. Let me ask each of you a question. Have you ever in your life been falsely accused of something? Have you ever been falsely accused? Have you had to sit there and take it and watch the proceedings and wait and wait and wait, all the while knowing you didn't do it? All you could do during such a process is to really maintain your dignity. Isn't that correct? Knowing that you were innocent, but maintaining your dignity and remembering always that all you're left with after a crisis is your conduct during it. So that's another reason why we're proud to represent this man who's maintained his innocence and has conducted himself with dignity throughout these proceedings. Now, last night, as I thought about the arguments of my colleagues, two words came to mind. And I asked my wife this morning to get the dictionary out and look up two words. The two words were speculative and cynical. Let me see if I can get those words that you got from me. Excuse me one second. I asked her, as I was thinking about this case, to go to Webster's, and I want you to tell me what does it mean to speculate? What does it mean to be cynical? As I thought about my colleagues' arguments and their approach to this case and their view of this case. Cynical is described as contemptuously distrustful of human nature and motives, gloomy, distrustful view of life. And to speculate, to engage in conjecture and to surmise, is to take to be the truth on the basis of insufficient evidence. I mentioned those two definitions to you because I felt that much of what we heard yesterday and again this morning was mere speculation. Understand this, ladies and gentlemen, that none of us in this courtroom were out at 875 Bundy on June 12, 1994, after 10:30 or 10:45 in the evening. So that everything we say to you is our best effort to piece together what took place in this case. When people theorize about things that may have been and talk to you about short fuses, you're going to see that's just that. It's speculation. People see things that are totally cynical. Maybe that's their view of the world. Not everybody shares that view. Now, in this case, and this is a homicide case and a very, very, very serious case. And of course, it's important for us to understand that. It is a sad fact that in American society, a large number of people are murdered each year. Violence, unfortunately, has become a way of life in America. And so when this sort of tragedy does in fact happen, it becomes the business of the police to step up and to step in and to take charge of the matter. A good, efficient, competent, non-corrupt police department will carefully set about the business of investigating homicides. They won't rush to judgment. They won't be bound by an obsession to win at all costs. They will set about trying to apprehend the killer or killers and trying to protect the innocent from suspicion. In this case, the victims' families had an absolute right to demand exactly just that in this case. But it was clear, unfortunately, that in this case, there was another agenda. From the very first orders issued by the LAPD so-called brass, they were more concerned with their own images, the publicity that might be generated from this case, than they were in doing professional police work. That's why this case has become such a hallmark. And that's why Mr. Simpson is the one on trial. But your verdict in this case will go far beyond the walls of Department 103, because your verdict talks about justice in America, and it talks about the police and whether they're above the law, and it looks at the police perhaps as though they haven't been looked at very recently. Remember, I told you, this is not for the naive, the faint of heart, or the timid. So it seems to us that the evidence shows that professional police work took a back seat right at the beginning. Untrained officers trampled. Remember, I used the words in the opening statement. They traipsed through the witness, through the evidence. And it was interesting because the prosecution didn't agree with that at the beginning, but later on in this trial, we heard Mr. Goldberg and talking to witnesses use my words, traipsing through the witness scene. That scene there at Bundy. He used our words because they understood. We knew what we were talking about. We were able to demonstrate it through the videos. They delayed unconscionably routine procedures in notifying the coroners. They didn't call the criminalists out on time. And yes, they allowed this investigation to be infected by a dishonest and corrupt detective. They did that in this case, and they may try to back away from it all they want, but that's very important, as you're going to see, to this case and the resolution of my client's innocence. Because of their bumbling, they ignored the obvious clues. They didn't pick up paper at the scene with prints on it. Because of their vanity, they very soon pretended to solve this crime, and we think implicated an innocent man. And they never, ever looked for anyone else. We think if they'd done their job, as we have done, Mr. Simpson would have been eliminated early on. And so this case is not, let me say at the outset, is not about attacking the Los Angeles Police Department. We're not anti-police in making these statements. You're not anti-police. We all need the police. I just said we have so much crime in this country, we need the police. But what we need, and what we must demand, what all of us should have, are honest, effective, non-biased police officers. Who could demand less? Can any of you say that's not what we should have? And so, let me tell you about how we're going to proceed here this afternoon. The defense has one opportunity, basically, to address you. This is after the prosecutors are finished. I will address you first, and after I'm concluded, and I will talk generally about the lay witnesses and an overview of the evidence and what you've heard. I'll strive not to bore you. I'll strive to be honest in my discussions, to be relevant, to be concise in what we talk about here. When I'm finished, Mr. Barry Scheck will come before you and address some of the forensic issues. And then finally, after Mr. Scheck finishes, I'll come back and conclude some concluding remarks regarding what you've heard over the course of the last 2 days at any rate. Now you understand that because the prosecution bears the burden in this case and in all cases, Ms. Clark will argue last to seek to rebut that which we bring up. And presumably she won't be back up here talking about all kind of new things. Seek to rebut that which we bring up. And let me tell you in front, if she brings up anything, we may be precluded from standing up and saying, wait a minute, Your Honor, here's the answer to that. But you can then substitute your common sense, your judgment in that place. And that's required in this journey toward justice. Now, at the outset, let's talk about this timeline for the defense. I said earlier that Mr. Darden did a good job in his argument. But one thing he tended to trip over and stumble over was when he started to try to talk about our case. He doesn't know our case like we know our case. It was interesting, wasn't it? Because first he stood up and started talking about the timeline being at 10:15. Then he said, well, they didn't prove anything, but golly, well, it may have been as late as 10:30. That's interesting, isn't it? Never heard that before. You look back and see what Ms. Clark promised you a year ago. 10:15. 10:15 was all they talked about. And they were going to use, because of the incompetence of this investigation, the wail of a dog. So we've been relegated to in this case because of this very, very poor investigation. But having said the defense doesn't have to prove anything, in this case, we did, in fact. And so Mr. Darden could talk all he wanted to about his theories about motive. They're just that, his speculative theories about motive. But when he came down to the end, he wasn't talking about motive, was he? He was trying to talk about our timeline. Why would he do that? Let's talk about why he would. Because the defense in this case called many witnesses who corroborate each other and who shatter the prosecution's timeline. Now, these are witnesses to a person who were known by the prosecution but discarded by the prosecution. Why? Because they didn't fit their tortured, narrow window of opportunity. So when you would visualize for me that jigsaw puzzle where they want to reduce this case down to a jigsaw puzzle, the part that deals with opportunity is the timeline. And we're going to start off with that because in a search for truth, let's look for the truth. Not some contorted, twisted truth, but the real truth, the facts that you've heard during the course of this particular case. We think after you look at this timeline for the defense, you will agree with our earlier analysis. This is a case about a rush to judgment, a case where there's been an obsession to win at all costs, and in the words of Dr. Henry Lee, something is wrong with the prosecution's case. Let's start off with Francesca Harmon. Francesca Harmon is the lady who left the dinner party on Dorothy at about 10:20 p.m. She drove west on Dorothy and Bundy and turned north on Bundy, so she'd be heading north toward 875. She saw nothing, heard nothing, no barking dogs. It's a lady known, of course, to both sides. And so you see this graphic regarding Francesca Harmon. And I think to familiarize you with that, I think at 10:20, as I understand, that's the approximate time that she would pass by or near Nicole Brown Simpson's home there. Oh, you see it with the X mark there in this graphic. That's Miss Harmon. We followed Francesca Harmon with Ellen Aronson and Dan Mandel. Remember the two people who'd been on their first date? They'd gone to Metzaluna. And they were interesting young people. I think you would find them credible. And by the way, you hold all witnesses up to the same standard. No side has a priority on the truth. These are witnesses known to both sides. We're the ones, however, who elected to call them and bring them here for you. You know how they walked home from this first date at Metzaluna, walking directly by the walkway at 875 South Bundy. And they said they passed by there. Remember, they were clear. They passed by there at 10:25. And you'll see the little kind of purple lines. Shows you the route they took. So they passed right in front of Miss Nicole Brown Simpson's home at 10:25, and you remember they continued on. So they were over on Darlington Street by 10:29. She said that it took them about 4 minutes from the time they passed 875 South Bundy to get home that evening. This was their first date, and I guess, as I recall, this was also their last date. They saw no blood. They saw no barking dogs. I submit to you, if the bodies had been there, they could have been seen. Now, why do I say that? I say that because we have a contact print in evidence. I'm going to ask Mr. Harris, if he can, to show us this contact print. This is an item you'll be able to take back in the jury room. Now, this is a photograph taken by Mr. Rokar at night, and it will let you see, Mr. Harris gets it focused, that scene that particular night, what you could see with regard to this body. And Your Honor, you may want to cut the feed on part of this. $33, Howard. Now, and this exhibit is what number, Mr. Do you have it? I believe it may be 86. I'll get it for you as soon as he takes it off, Your Honor. Now, this exhibit, and we'll try to give them to you, Your Honor, just when we first get them up there.
Thank you.
This exhibit, number 86, was a photograph that we got late in the trial of Mr. Rokar. The photographer was called by us. You see that document over there? That's a contact sheet. Remember, he talked about all of these photographs in sequence in this first roll were taken at night. This is going to be a very, very important role for you as this case progresses. This is a photograph at night of what you could see from across the street, and there were lights in and around there. And so when Mr. Darden stands up here as an advocate and tells you it was pitch black and you couldn't see anything, this is the photograph that was taken before the sun came up. This photograph was taken at night. It's not pitch black. We know also that according to the evidence, blood had flown down that walkway. There were bloody paw prints that went southbound on Bundy there. So you see that photograph? You see that photograph? Now, you can be an advocate, and we're all sworn to do the right thing. We talked about his oath. Well, your oath is also to tell the truth. It's not pitch black. We have the evidence. And I'm going to try to do that throughout. Where they have misled you or said things that weren't correct, I'm going to try to straighten it out for you. Mr. Harris, why don't you tell the court now what that number is? So it's number 1369, and that's Mr. Rokar. We're going to come back to some other photographs on that, but you'll recall his testimony. And the reason why 1369 is so important is because it is undisputed that at 1025, Mandel and Aronson walked past there. If there was blood down on that sidewalk, if there had been a killing had taken place, if there were dogs barking or wailing, don't you think, given that, if you've been out there, you'd see it. So the time has come now to stop all this folly and fantasy. Let's deal in reality and in the facts of what took place and what you can see with your own eyes. I don't want you to speculate or theorize. When I sit down, I want you to understand what the facts are of this case. Hey, Mr. Harris, you can take that down. After that, we had Denise Pilnack and Judy Tillander. You know, and I think, again, as advocates, we have a responsibility to treat all of these witnesses with respect. These people didn't ask to come down here. These people don't ask to be maligned. I don't think anybody really wants that, with the exception of one or two. And most of them were called by the prosecution. So when Denise Pilnack, the lady who wore 2 watches, comes in here and tells you, I ask you to judge her credibility like you do all the witnesses. The court has instructed you. You hold all witnesses up to the same standard. You look at the reasonableness of what they have to say. You look at their bias or interest. You look at their demeanor on the stand. You use your common sense. You use your visceral reaction, if I can use that word, to make a determination of whether or not you think this person is telling you the truth. None of these people know or knew O.J. Simpson. With the exception of the people who are together, they don't know each other. They're witnesses available to both sides. But in the search for truth, we're the ones who subpoenaed them and brought them in. Let's look at Denise Pilnack. She tells you that she was at home with her friend Judy Tillander. She's across the street from 875 South Bundy. She's south and across the street. You recall that. She spoke of how eerily quiet. Remember those words? It was at about 10:24 p.m. when Tillander left her house. And she remembered that because she wanted to get Tillander out of there. She'd been there all day, and she wanted to use a computer or something to type some letters. Remember that? So she went outside on the porch with Tillander, as I recall, and Pilnack just didn't come to you and tell you that. Pilnack did something else. She, and I believe, Your Honor, that's Exhibit 1237. She showed us
phone records.
the phone record, Your Honor. She showed us that she got on the phone as soon as Pilnack left and called her mother, remember she said, in Gardena. And you look there on June 12th at 10:25 p.m., she made a call to Gardena. She was able to fix the exact time that her friend left. And she said to us something very interesting, that there was quiet when her friend left, and the quiet continued for at least another 10 minutes. So that would be 10:25 to 10:35 at the earliest. She says that at 10:35, it's the first time she heard dogs barking loudly that particular night. And so that she, as you will see along with Robert Heidstra, confirm each other. They don't necessarily know each other, but they confirm each other as to when this barking really began. Now, they weren't laying in bed and had been asleep like Eva Stein. They weren't like Miss Elsie Testert, who was across the street, who didn't really know what was happening. These are people who are either outside or in that area who can come in here and tell you why they remember these particular times. They were wide awake, up and about, outside, around the time when this barking took place. Then we call this man Robert Heidstra. You know, because it came out that Robert Heidstra had been talking to the prosecution. Remember what he said. Now, this is the man who's an interesting man who details cars. He's the man who is well known to the prosecution. Remember, he talked to Detective Payne almost right away during the investigations to Payne. And he told Payne the same thing he told you during the course of this trial. Here's what he said. He says that he lives nearby, and he has these two elderly dogs, one of whom I recall was 14 years of age. And so these dogs walk kind of slowly. Remember that? He walks and he takes this route. And that graphic up there shows you the route he takes. Let me tell you, he left home a little bit late that particular Sunday evening. So 10:15, he leaves home. And he proceeds on this route. And you know he's in that alleyway that runs parallel with Bundy. And he knows this neighborhood. He's been doing this for more than 14 years. He knows not only the neighborhood, he knows the dogs, he knows their barks, he knows the gates, he knows when they clank, he knows all of that. And isn't it an interesting situation? Wouldn't you thought that of all the witnesses in this trial, in this journey toward justice, this is the only witness who ever heard any voices. But they didn't call him. You know why? Because it doesn't fit in their timeline, as you're going to see. And so he tells you that, and you recall, he's directly opposite Miss Nicole Brown Simpson's condo in that alley when he hears what he believes is the Akita start barking. And that's at about 10:35 p.m. He recognizes, he says, the Akita's bark since he walks that way, that same way, each and every evening. So while in that alleyway, east of 875 South Bundy, here's a voice yell, "Hey, hey, hey." And he says he then hears a gate slam. Now he goes on and says that at about 10:40, 10:45, he sees this white vehicle, which he describes clearly as a van or a Jeep. Now they were trying to tell you all these things about it being some Bronco, but he never said anything about any Bronco. He said a van or a Jeep. And the important part was, that's what he tells the detective, but he says it goes southbound on Bundy, away from where Mr. Simpson would live. And could you imagine in this area, in West Los Angeles, in Brentwood, the number of white vehicles there are and must be in that particular area? But the reason why they didn't call him was because at 10:45, O.J. Simpson cannot be guilty of this crime, can he? Now, how do we know that? How do we know that, ladies and gentlemen? Well, yesterday, in her zeal and advocacy, Ms. Clark tried to push the time back from 10:40 or 10:45 that Cato heard those thumps. She tried in her chart there to push it back, remember, to 10:53. Some of you probably were surprised. There's been no testimony about that. So let me tell you, let me quote for you. Counsel, this is page 19873. This is Ms. Clark talking to one of her favorite witnesses, Mr. Cato Kalin. By Ms. Clark. And what happened with that picture when the thumps occurred? The picture tilted from, that would be right to left. The picture moved. Answer, yes it did. At that point that you heard the thumps on the wall, sir, approximately how long had you been on the phone with Rachel Ferraro? Remember, he called his friend, called his girlfriend. About a half hour. This is after he went back in the house, he called his girlfriend. And so approximately what time was it when you heard the thumps on the wall? Answer by Mr. Kalin, at about 10:40. At about 10:40. Now this is the time when the dogs first start to bark over there. At about 10:40. Is that exact 10:40, Ms. Clark says? Well, what I remember, I didn't look at the clock, but around 10:40. Question, do you recall previously testifying that it was 10:40 to 10:45? Answer, yes. Question, okay, and is that correct? Answer, yes. Now, that's their witness. That's their witness. That's what he has to say. There's no question he's there. They know he's there. You know he's there. They don't call him. What about this search for truth? Can they handle the truth? You will be making that kind of decision. And so, we then know, according to this, that by the time Hydra sees this vehicle turn south on Bundy, Cato Kalin has already heard the 3 thumps on the Rockingham wall outside of his room. And you know, that's so interesting because yesterday Ms. Clark tried to change how those thumps sounded. Now remember, this is something that you will never forget probably. I won't come all the way over there, but let me just see if I can duplicate. Cato Kalin said, here's how he said those thumps sounded. 1, 2, 3. Except he used that place up there. He said they were thumps. Almost like a signal. 1, 2, 3. Is what he had to say. And of course, you'll recall that. Your notes are much better than ours, I'm sure. Apparently the prosecution, in their zeal and their obsession to win, would have you believe that Mr. Orenthal James Simpson is so amazing that he can be in two places at the same time, even though they're miles apart. And when Darden was talking to you today, remember he used Heitzer to say, well, on a Sunday evening, you could make it over there in about 4 minutes. And he said that? Well, in their own drive-through, that Van Adder did, took between 5 and 6 minutes. You saw it. Took close to 6 minutes. He didn't tell you that again today. And if you want to get a flavor for how, we heard the word desperate a couple times, but how witnesses were treated. Just ordinary witnesses, regular citizens. Let me share with you a transcript regarding Heitzer. Counsel, I'm going to be looking at 36368 through 36370. This is how Mr. Darden treated this witness who helped to shatter their timeline and establish O.J. Simpson's innocence. Didn't you tell us yesterday that the voice was a youthful voice? Yeah, it sounded like a young voice. Okay. And when you heard that voice, you thought that that was the voice of a young white male, didn't you? And there was an objection, you may recall. The voice sounded like the voice of a white male, Mr. Darden said. Answer, how could I say that it is a white male? I don't know the voice. It could be anybody there. Question, did you ever tell Mr. Stevens, my investigator, that it sounded like a white male? Answer, no. Never saw Mr. Stevens come in here and say that. Never said that? Answer, I don't recall that at all. I said it was a clear voice, but never what kind of white or brown or yellow. And then there was that second voice, correct? Right. And that second voice, that voice sounded deeper than the first voice, didn't it? Answer, a little bit, but I couldn't hardly hear it with the dogs, the commotion with two dogs there. It was very short. Did you ever tell anyone that the second voice was a deep voice? Answer was deep. It was deeper than the other one, then hey, hey, hey. Okay. And then we get to the question. At line 22, Counselor. The second voice that you heard sounded like the voice of a black man. Is that correct? Objection. The witness, of course not. Now, you know, we can be advocates. Those questions, nobody ever came in to impeach that man. He told you he heard two voices. He told you when this took place. He told you why, because he walks his dogs. He knows that neighborhood. A search for truth, you see, their job is not to just try to convict. Their job as prosecutors is to make sure the innocent go free also, to make sure all the witnesses come to your attention, as we've had to do in this case. So you can see that these responsible citizen witnesses who came before you were oftentimes treated roughly and ridiculed and attacked by the prosecution in their obsession to win. You don't think Heitzer was attacked? Remember, he was asked the question, something to the effect, are you a citizen here? Because he's from France, apparently. And something about his job and his little apartment, because he's a car detailer. Everybody is entitled to dignity. That's what we fought for in this country. You don't treat witnesses who just come in here, they don't get paid to tell the truth like that, just purely and simply because they're not saying what you want them to say in your contorted version of what the truth ought to be. But you saw that yourself. I don't have to tell you about it. Interestingly enough, they chose not to mention even one of the defense witnesses in Ms. Clark's discussion of her timeline. The prosecutors noted that none of their timeline witnesses asked to be involved in this case. Well, none of the witnesses that we call asked to be involved in this case. They came forward. You saw how they were treated. But yet they told you what they observed. But perhaps the most important thing about them is these aren't any family members. These aren't people who know O.J. Simpson. These are just people who happen to be out there that particular night. And I think you can now see from that graphic how they all passed by there. We tried to make it as clear as we could. It's common sense. It's common sense, just like he said. It becomes very, very clear right at the outset. So if you accept the prosecution scenario, there's not enough time for O.J. Simpson to commit these murders, given the evidence that we understand. Let me just succinctly at the beginning help you understand where I'm going on this. Remember Bodziak, they like to talk about so much? When F. Lee Bailey cross-examined Bodziak the first time he was here, remember Bailey got him to say this remarkable thing about whoever left out that back gate turned and went back the other way. It's pretty interesting because I didn't see all those prints, but that's what he says. They went back to the scene. Remember that? That's what Bodziak said. Darden said this morning, the killer or killers that went that way, they weren't in any hurry. They went that way and then came back. You take that along with the fact that the credible evidence regarding this struggle is it took between 5 to 15 minutes. Now that's what Dr. Henry Lee, Dr. Michael Batten said. They not only told you that, they showed you why that was true. You know, while I'm about it, just to digress for just a moment, Mr. Darden talked this morning about calling witnesses and not calling witnesses. Isn't that interesting? Now, they're the prosecutors. They are the ones who have the burden. In the history of man runneth not to the contrary. Nobody around here can remember any time that the coroner who did the autopsy, the actual autopsies on these bodies, wasn't called by these prosecutors. Why do you think that was? They didn't call the coroner. They chose instead to call Dr. Lakshmanan, who came in here. They showed you what they thought about him. They talked about this man so badly. I mean, for 8 days, we heard Dr. Lakshmanan talk to you. They talk about length of time in this trial. Let me put that in perspective for you. For 8 days, Lakshmanan sat on that stand and went through direct examination by Brian Kilburn. Check your notes if you think I'm wrong about that. Bob Shapiro got up and took 3.5 hours and demolished him because at the end of the day, Lakshmanan told you this. Well, these were deaths that were caused by stab wounds. And the time of death was between 9 and 12. Remember all those discussions about big-ticket items and big-ticket items? And when you get back in the jury room, you'll have a lot of fun trying to figure out all those red and blue marks that they drew all over the corners. They spent 8 days trashing their own coroner. And they didn't call him. Now, why is that in this search for truth? They call somebody else who's not even there at the autopsies, who has the benefit of our experts, Michael Batten and Barbara Wolf, who point out to him the mistakes that Golden has made. He then runs in here and testifies about those mistakes that we had discovered. Remember, ladies and gentlemen, in this search for truth, our experts were in place right away. O.J. Simpson was paying for these experts to find the killer or killers. And you'll recall the evidence that Dr. Lee, Michael Batten, Barbara Wolf were offered to them at the beginning. So the idea is that from the beginning, there was this search for truth. So I mentioned that parenthetically at this point because I think it's important. We talk about not calling witnesses. In every murder case, it's basic that you got to call the coroner. But they did a number of things in this case, ladies and gentlemen, that had never been seen before. Off the top of our heads, 4 detectives going to the scene to notify somebody who's not even the next of kin. The detective carries blood 25 or 30 miles around in his pocket. They do things that you have never heard of before. In this case, is it because it's Orenthal James Simpson? And so as we look then at the timeline and the importance of this timeline, I want you to remember these words. Like the defining moment in this trial, the day Mr. Darden asked Mr. Simpson to try on those gloves and the gloves didn't fit. Remember these words. If it doesn't fit, you must acquit. And we're going to be talking about that throughout. So to summarize, if you take the witnesses who we presented, who stand unimpeached, and if you are left with dogs starting to bark at 10:35 or 10:40 let's say, and we know from the most qualified individuals, Henry Lee and Michael Batten, this was a struggle that took from 5 to 15 minutes. It's already 10:55. And remember, the thumps were at 10:40 or 10:45. O.J. Simpson could not be guilty. He is then entitled to an acquittal. And we have talked to you, and you've heard from the court, and my colleagues talked to you about this whole idea of circumstantial evidence. I want to talk to you a little more about that now. We have shown you the incredible evidence that it would be impossible. O.J. could not, would not, did not commit these crimes. And where you have a circumstantial evidence case, this becomes very, very important. The prosecution then must disprove our timeline beyond a reasonable doubt. And if they don't, you must acquit. He would then be entitled to an acquittal. So let's see if we can look quickly at this jury instruction, sufficiency of circumstantial evidence generally. Mr. Douglas is going to help me today. Have just a second here.
Really?
Douglas? Now, in both places, you can see this instruction. It's called sufficiency of circumstantial evidence, evidence generally. And to be as accurate as possible, let me allude to all of it, lest I favor one portion or the other, and together we can consider it. This is the law that His Honor has already given you as relates to circumstantial evidence, which this is in this case, about opportunity to commit these crimes. However, a finding of guilt as to any crime may not be based on circumstantial evidence unless the proved circumstances are not only, one, consistent with the theory that the defendant is guilty of the crime, but two, cannot be reconciled with any other rational conclusion. Further, each fact which is essential to complete a set of circumstances necessary to establish the defendant's guilt must be proved beyond a reasonable doubt. In other words, before an inference essential to establish guilt may be found to have been proved beyond a reasonable doubt, each fact or circumstance upon which such inference necessarily rests must be proved beyond a reasonable doubt. Also, if the circumstantial evidence as to any particular count, either one of these counts, is susceptible of two reasonable interpretations, one of which points to guilt, the other which points to innocence, you, as jurors, must adopt that interpretation which points to the defendant's innocence and reject that interpretation which points to his guilt. If, on the other hand, one interpretation of such evidence appears to you to be reasonable and the other interpretation to be unreasonable, you must accept the reasonable interpretation and reject the unreasonable. I put that up at this very moment because you've just seen the timeline, which is circumstantial evidence of O.J. Simpson's innocence because he couldn't have done the crime given this time. So under that scenario, even if the prosecution's timeline was reasonable, if they're both reasonable, I think you must agree ours is reasonable, it becomes your duty to adopt that which points towards innocence. But even further, if theirs is unreasonable and ours is reasonable, he's still entitled to an acquittal. The only way they're entitled to conviction, ours is unreasonable and theirs is reasonable. And I think you can see and understand that's not true. That shouldn't happen. That's not the facts of this case. So before I look at their timeline, let me just see if I can summarize what I believe the prosecution has tried to tell you about their theory in this case. And this is just kind of rough, but listening to them yesterday, they tried to tell you that an insanely jealous man stalks his ex-wife, stabs her and a male visitor in a murderous rage, leaves a trail of blood to his home, barely catches a plane for Chicago, in a rush to go there, leaves one glove at the murder scene and one glove behind his house. In the defense of this case, you have heard evidence about O.J. Simpson's great life. Not only was he have a great life, he had a great day that day. Playing golf, comes back from being out of town all week long, comes back to go to his child's recital. He goes to that recital, prepares in the evening, gets something to eat, a hamburger. By the way, I have to stop at this point. I'm glad Miss Clark doesn't know this, but you know, if you've ever been to McDonald's, they don't like you to bring $100 bills in there. You know, you can't get $100 bills changed there generally. So some of these things about common sense, some people don't know.
Beyond the evidence here.
Well, all right, thank you.
Proceed.
Use your common sense about fast food places. He then takes a shower, barely catches his plane in Chicago. Someone murders his wife and this male visitor for reasons unknown in this trial. Others seek to implicate him as the most obvious suspect. The investigation becomes a tragic combination of sloppy errors and cover-ups to try and achieve his conviction. Those are going to be pretty much the hypothesis that you've heard and will be hearing in this case. Under whatever scenario, based on what I've already told you in this first hour of the argument, this man is entitled to an acquittal. But let's now turn briefly to the prosecution's timeline scenario. And you heard Ms. Clark yesterday talk about this timeline and talk about these witnesses, and she relies very heavily on this Pablo Fenves. You remember him. He's one of the early witnesses who started off, I think, talking about a plaintiff wail of a dog at 10:30, and he got pushed back to 10:15. But it's interesting because now Darden, not Marcia Clark, has now come back and conceded, well, you know, maybe it really was later. They did a pretty good job. You know, so he's saying that. But Fenves told us that he, you know, he's in that alleyway, down the alleyway and across from Nicole Brown Simpson lives. 10:15, 10:30, whatever, 10:20. Eva Stein, next door, was asleep. Claims she was awakened. You ever wake up at night? You might see the time right, you might not. She says about 10:20 or so, she thinks she hears dogs barking. Well, I presume the dogs bark throughout that neighborhood all the time. And we don't know, and that's the problem with trying to convict somebody or set the time of death by a dog barking. Louis Karpf, her boyfriend, comes home sometime after 10:20. And then, of course, Miss Elsie Tistert, the lady from across the street, doesn't know when or what was precisely when she heard the barks. Then there's Mark Storfer. And Mark Storfer is an interesting man because you remember he's the man who always set his watch 5 minutes fast, he says, presumably. He told us here in testimony, counsel 17190, says at 10:28 is when I looked at the TV, which was a couple of minutes after I'd gotten in the room. Right? Okay. And then he talks about, I looked out the window of our bedroom that faces North Bundy to see if I could see where that dog was or what was going on. It was pretty dark, and I couldn't see anything unusual, and I couldn't locate the dog. I also looked out the west-facing window of our bedroom to see if the dog was further over to the west. We faced the alley on the west side, and I could not see anything at that time either. Now, this witness becomes kind of important, doesn't he? Because the prosecution is going to tell you that no matter what time it is, whether it's 10:40 or 10:45, or whether it's 10:15 or 10:20 or 10:25, or Mr. Darden makes this big quantum leap. The Bronco was there. Where's Mark Storfer, who looks down that alley, and what exhibit is this, Mr. Harris? Do we know? Exhibit number 38, Your Honor. This is looking northbound down that alleyway. And you recall this because we've all been out there, and you'll recall where Miss Nicole Brown Simpson's condo is located, and you'll recall that it's sitting out in the driveway there, right there. It was a black Jeep Cherokee, as I recall. And you see, this man can presumably look up this alleyway. He didn't see any white Bronco. Nobody ever tells you about any white Bronco parked back there. Doesn't tell you about any car parked back there. So when you see people tell you about mountains of evidence and oceans of evidence, their oceans soon become little streams. Their mountains become molehills when you look at the facts. And so we go on. In addition to Mark Storfer and looking up that alley and seeing nothing or seeing no car or doesn't see a dog, we hear about the other witnesses who become pretty much part of the timeline. Ms. Clark does take some licenses regarding time. She says that Mr. Goldman leaves Mezzaluna, she says about 9:50 p.m. Says he goes home and he changes clothes, that he talked to Stuart Tanner about getting together later that evening. Remember that? Talked about going to Baja Cantina out at the marina. You know, wouldn't you think it would be logical to expect if he worked all day, when he went home to change clothes, he might have showered, he might have gotten something to eat. Especially if later on, when you hear Mr. Scheck, you look at the amount of food, undigested food, that was still in the stomach of these two victims. But in a rush to judgment, in a rush to contort these facts, Ms. Clark tells you yesterday, let's give him 5 minutes. He's been working all day. He's got to change clothes. He's got to come home. Let's give him 5 minutes or 10 minutes. To be correct, she says, let's give him 10 minutes. That seems to me to be really, really fast. And what it really is, ladies and gentlemen, is more of that speculation. She doesn't know how long Mr. Goldman was there. None of us know that. We know he changed clothes. She has absolutely no idea. But so you understand that when you look at when somebody says something like that to you. And then as part of their timeline, she tells you yesterday that there's something sinister in Mr. Simpson seeking change to buy a Big Mac from McDonald's. I suppose that if you're in this jealous rage, if the fuse is running so short, it's interesting, isn't it, to stop, go get a hamburger at McDonald's. Does that make any sense to any of you? Does it make any sense to you to drive to McDonald's? And there's no evidence that he tried to tell Cato Kalin not to come. The evidence is that these two men got in the Bentley and went to McDonald's. The evidence is that while O.J. Simpson is in this murderous rage, he's worried about money to tip the skycaps at the airport because he has $100 bills. So he gets $20 from Cato Kalin. What's unusual about that? Cato Kalin's living there for free, so I suppose he could give him $20. Then Cato Kalin wants to go get something to eat. And Ms. Clark says they could have gone to a restaurant. Well, you could do anything, I suppose, but the facts are they went to McDonald's to get a hamburger. O.J. Simpson ate the hamburger. Presumably, he was hungry. Now, what's sinister about that? Unless you're cynical in your view totally of this case. Cato Kalin, their witness, they called him. They turned on him. You observed him. I ask you to hold him up to the same standards you do all the other witnesses. But I ask you, don't misquote him. Tell the truth about what he had to say. And so when he says 1040, or 1040 to 1045, don't try to make it 1052. So if you believe in this prosecution's theory, there's this blood leading down to this rear walkway, and Ms. Clark told us yesterday and unveiled her theory. Here's what they ask you to believe. O.J. Simpson comes home from these brutal murders in a Bronco that he must be driving awfully fast to get back in this time frame. He parks this Bronco out there, the Rockingham gate, somehow gets in the gate, gets down the side of his house, and what does she tell you? He bumps into the air conditioning. Now let's examine that for a minute. The evidence is that O.J. Simpson has lived at this house for 17 years. Who do you think knows this place better, or the best of all? This is his estate. This is where he lives. This is where he's raised his children. This is where he's been married. This is where he had 2 marriages. He knows this place. So as part of their fantasy, their theory, their speculation, they have O.J. Simpson walking down this walkway, running into an air conditioning. Well, he ran into the air conditioning. Where's all the bruises that he got from running into the air conditioning? Where's the sound that he made? That doesn't make any sense. You see, the reason why they come up with this running into the air conditioning, because they can't say he climbed over the fence, because there's too much shrubbery there and it's not broken. Now, you really don't know if he could climb over the fence with this arthritis. But they have him then walking down this walkway, bumping into the air conditioning. But ladies and gentlemen, you know, we're talking about common sense here. Bumping into the air conditioning, and then he just leaves. Is that what happens? And let's look at this. Thank you, Mr. Douglas. You all remember this. And what exhibit is this, Mr. Douglas? Excuse me. 116. I'll stand over here so I won't be in your way. Thank you. Under this scenario, under their scenario, while Allan Park is out here somewhere looking over in this direction, they have O.J. Simpson rushing back, parking the Bronco out here, and somewhere or other, he gets all the way down here. Remember, Furman told you how far that was. Gets all the way down here where this air conditioning is, out here by Cato Kalin's room. You'll see this right here. They have him running into this air conditioning, so he doesn't know his own house. And he's all the way back here, and she says the reason he's back here is because he's going to go back here and he's going to bury the knife in the clothes. Now, isn't that something? How does she know that? Just make that up out of whole cloth? Do you believe that's reasonable? Is that reasonable to you? Does anybody on this jury believe that? That's what you were told yesterday. He runs in this air conditioning and then just, you know, he bumps in it and he drops his glove. That's what she told you. Doesn't make any sense at all, does it, ladies and gentlemen? Doesn't make any sense at all. No sound from Cato Kalin. And then what kind of, you know, the sound has always been very confusing. Maybe not to you, but to me. Cato Kalin goes, it's more like a signal than anything else. Come out here or whatever. But those are the facts of Cato Kalin and what happened. And that's her theory. That's her reasonable, rational theory that you have to buy into, which I think that you will find to be totally ridiculous. Now remember, down this same way, there is a door into that side room there. Mr. Simpson wanted to get in his house. What would stop him from going in that side door? Who knows his house better? He wanted to not be seen. I'm supposed that he would know better than anybody else. Doesn't make any sense. Doesn't make any sense at all, what they're now trying to tell you. And here's something else. that's equally implausible. She tells you that the reason why Mr. Simpson couldn't stop and hide these clothes is because he's too famous and too well known. Remember that? She said O.J. Simpson is too famous and too well known to stop and try to hide clothes or whatever of that nature. Well, let's take that just a little bit further. Part of what makes their theory so ridiculous is it is O.J. Simpson going to get in a white Bronco that's well known in Brentwood, drive over to his ex-wife's house, park the Bronco in this well-lit alleyway that you've just seen, leave the car there, everybody knows him, knows that car. That's equally preposterous. So she can't have it both ways. He's too famous to stop and try to throw things in a dumpster, the way she put it. Isn't he equally too famous to be driving this car to go over there under these circumstances? That is preposterous. So if you believe the prosecution's theory, and they told you all this about a bloody trail, where's the blood back there, ladies and gentlemen? There's not one drop of blood. Where's the blood back there? Where's the trail that leads to that glove? And further, look at this. Look at this, ladies and gentlemen. It's not something I'm making up. You're seeing this with your own eyes. Look at the glove. Now, when that glove is picked up, do you remember is there any blood on the ground? Any blood on that shrubbery? Any blood on anything there? Where's the blood? Furman and Van Adder, as we discuss them later, will say that when they get that glove after 6 o'clock in the morning, it's still moist and sticky. Remember their testimony? Where's the blood on the ground? Where's the blood on the leaves around there? Where's any of that? That glove looks as though it's been placed there. That glove looks as though it's been placed there. If you look at A, you'll see how far it is out to the street. So their theory doesn't hold water. It doesn't make sense. And so they get mad at Cato Kalin. And they tell you why he's biased. He's just indebted to O.J. Simpson. So we just can't trust him. But yet they want you to trust him about the knocks on the wall. And he becomes part of their theory. But their theory doesn't make sense. And when you were back there deliberating on this case, you're never going to be ever able to reconcile this timeline and the fact there's no blood back there, that O.J. Simpson would run into an air conditioning on his own property. And then under her scenario, he still has the knife and the clothes. But what did she tell you yesterday? Well, he still has the knife and he's in these bloody clothes and presumably in bloody shoes. And what does he do? He goes in the house. Now, thank heaven, Judge Ito took us on a jury view. You've seen this house. You've seen this carpet. If he went in that house with bloody shoes, with bloody clothes, with his bloody hands, as they say, where's the blood on the doorknob? Where's the blood on the light switch? Where's the blood on the banister? Where's the blood on the carpet? That's like almost white carpet going up those stairs. Where's all that blood trail they've been banding about in this mountain of evidence? You'll see it's little more than a river or a stream. They don't have any mountain or ocean of evidence. It's not so because they say so. That's just rhetoric. We, this afternoon, are talking about the facts. And so it doesn't make any sense. It just doesn't fit. If it doesn't fit, you must acquit. And so she has him then still with the knife, still with these bloody clothes, and then she does something very unusual. Again on the time. Remember, she gave Mr. Goldman 10 minutes to get dressed and to go over to Nicole Brown Simpson's house with this envelope. Mr. Simpson, she says, who walks in this house in the walkway, and by the way, they were wrong. She was wrong about something else again I'd like to read you. She's wrong in her description of Allan Park. If I can locate it. Allan Park says he saw this figure in the walkway only. And so that we're clear about that, let me just read it to you. I don't have to just tell you what I think it is. I'm going to read it for you. 20571, counsel, line 17. Yes, I saw a figure come down, well, not come down, but I saw a figure come into the entranceway of the house, just about where the driveway starts. So a figure come into the entranceway of the house, just about where the driveway starts there. Do you see that right there, the driveway is? That's what he said. Yesterday they were trying to put it all down here and have him come, because that was convenient to their theory. But that's not what the witness said. You look at the facts of this case and you'll see, not what they tell you. Continuing it on. There is absolutely no evidence at all that Mr. Simpson ever tried to hide a knife or clothes or anything else on his property. You recall that Furman, and when I get to Furman, we'll be spending some time on him, as you might imagine, but one of the things he said was that he encountered cobwebs further down that walkway, indicating, if that part is true, and I don't vouch for him at all, there's been nobody down that pathway for quite some time. And so she talks about O.J. being very, very recognizable. She talks about O.J. Simpson getting dressed up to go commit these murders. And just before we break for our break, I was thinking last night about this case and their theory and how it didn't make any sense and how it didn't fit and how something is wrong. It occurred to me how they were going to come here and stand up here and tell you how O.J. Simpson was going to disguise himself. Was going to put on a knit cap and some dark clothes, and he was going to get in his white Bronco and this recognizable person and go over and kill his wife. That's what they want you to believe. That's how silly their argument is. And I said to myself, maybe I can demonstrate this graphically. I'm going to show you something. This is a knit cap. I'm going to put this knit cap on. And you've been seeing me for a year. If I put this knit cap on, who am I? I'm still Johnnie Cochran with a knit cap. And if you look at O.J. Simpson over there, and he has a rather large head, O.J. Simpson in a knit cap from 2 blocks away is still O.J. Simpson. It's no disguise. It's no disguise. It makes no sense. It doesn't fit. If it doesn't fit, you must acquit. Good time, Your Honor.
All right, ladies and gentlemen, we're going to take our mid-afternoon recess at this time. Remember all my admonitions to you. We'll stand in recess for 15. All right, back on the record in the Simpson matter. All parties are again present. All right, we'll let the stragglers get in here. All right, Deputy Trier, let's have the jurors, please. be seated. And let the record reflect that we've been rejoined by all of our jury panel members. Good afternoon, ladies and gentlemen, again. And Mr. Cochran, you may continue with your final argument.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Thank you for your patience thus far, and we'll start up again and see if we can make it to dinner. When we left, just before we broke, I was sharing with you a knit hat or knit cap that we've heard so much about in this case. And it reminded me that there was testimony early on that Detective Lang had refused basically to pick up a knit cap inside the Brown residence that was shown to him, I think, by some of the lawyers and one of the investigators on that date, because these are fairly common. But they don't really disguise anybody who's noticeable, do they? And although I was the guinea pig here this afternoon, if you were to put a knit cap on, how's that going to disguise you? We've been together. I'd know your face anywhere now, and you'd know mine. And the people in Brentwood, in West Los Angeles, would know O.J. Simpson. They know his car. They know him. That's where he lives. Even the prosecutors say he's so famous that he can't go anywhere where he wouldn't be recognized. Now, one of the things about this people's timeline or whatever is that you recall that some of O.J.'s bags were already packed outside of the house on that bench when Cato came outside to investigate the thumps, which he'd heard. And this is interesting because the prosecutors have kind of talked at cross purposes on this. Cato at some point comes out because he hears these thumps, allegedly. And he has a little tiny flashlight, or I think the court called it a pen light or a mag light or something like that. And it was something small because it's dark back down that walkway. Apparently he went part way down that walkway, and then he came back. It's interesting, isn't it? He came back, and at some point he lets Park in. I remember all these questions about opening the gate and everything. Remember, there's a dog there. Isn't there a dog there named Chachi? There's a lot of talk about these dogs, and you've heard a little bit about these dogs. But one thing that I think is the prosecutors make these kind of wild speculations, you now know that the Akita dog was bought by O.J., as was Chachi. Because remember, one of the dogs died, and like a good dad, he let the dog stay at the other house sometime with his son Justin. And they named the dog after Cato, was I think the understanding of what you've heard from Arnell. But at any rate, I point that out because we know there was another dog over there named Chachi, a black dog, black chow. But while Cato is out looking for these thumps, what happens to these thumps, Mr. Simpson talks to him. In fact, they go in the house together because Mr. Simpson is going to help him look or help him find a larger flashlight. And then someone says, or he's reminded, that Mr. Simpson is running late for his trip. So then he takes off. My understanding of the facts is Mr. Simpson said, I'll call you later and have you put the alarm on, because he was getting out of there. Parks was already there. But I think the interesting thing to remember is that some of the bags were already down, including that golf bag, were already down there. This was not any unexpected trip. He started putting things down there. If you look at everything in a cynical fashion, you heard this morning, aha, there was a knapsack over, or nap bag, or some little bag they were talking about over in the driveway. Well, if you're a golfer, isn't it reasonable to assume there's golf balls in there? And if you put that in your golf bag, I mean, what's the big deal? Because they've got to try to theorize and try to explain everything, which they can't explain. They weren't there. They rushed to judgment, and it leads to this kind of wild speculation. You have to do that when you don't have a case. And that's all you've seen them do time after time after time. With regard to that walkway, lest I be totally clear to you, if O.J. Simpson had been the one, for whatever reason, to walk into that air conditioning, where's the hair and trace? Where's the fiber? Where's the blood? They want to tell you about his hands, fingers bleeding 1 minute, and it stops bleeding. In Miss Clark's scenario, he bleeds, it coagulates, stops bleeding, then it starts bleeding again, because that's convenient for her theory. You know, as I listen to both of them, I wanted to call them doctor. Dr. Clark, because Dr. Clark told you, well, gee, look at that blood drop. That cut wasn't big enough for that blood drop. She's not any doctor. How does she know that? Dr. Darden, for the love and the forlorn. He knows everything about relationships. He just speculates on and on and on. He's got this great, vivid imagination. The only thing is, this is real life. This isn't anything from Murder, She Wrote. If they tried to sell this story to Murder, She Wrote, they'd send it back and said, that's unbelievable. You're going to see that as we tie it together. But it's nice to have vivid imaginations, but not in this courtroom. Because here, you are searching for truth on this journey for justice. So we know that Cato had some concerns. He was looking around. We know that at some point, Mr. Simpson comes down the stairs carrying the Louis Vuitton bag or whatever, and then Mr. Simpson leaves about 11:02 for the airport. I think that's pretty clear based upon the evidence. And you'll recall that Ms. Clark again gives Mr. Simpson 5 minutes to rush in. According to her theory, he rushes in, changes clothes, disposes of all these clothes, showers, packs, does everything, and comes downstairs and says, composes himself. Now, can you imagine that? I mean, who do they think they're talking to? In 5 minutes, he does all these things. And then they tell you that, you know, under this post-homicidal way you act, you get yourself all composed and you just do this. This is preposterous. They're not experts. They can't testify. Those are just their wildest, rankest theories. You use your common sense when they tell you things like that. O.J. Simpson was O.J. Simpson, the way he always appeared by the people who knew him and talked to him. We'll talk more about that when we talk about demeanor. But the reason they can't explain his demeanor and the way he acted like he always acted, they then talk about, well, you can't tell who's a murderer. I mean, those are all real convenient words, aren't they? But they fly in the face of reasonable activity by a reasonable man on that particular night. So there's Allan Park. O.J. Simpson comes down within 5 minutes of the time they believe he goes upstairs. No time to dispose of bloody clothes. What about blood on the carpet? What about dirt on this white carpet? How does he shower? How does he get dressed? I mean, it doesn't make any sense at all, does it? Park himself says the golf bag was already packed and ready to go when he pulled into the driveway. And Miss Clark went to great trouble to tell you how credible she thought Mr. Park was and how he tried to lay everything out. And I think, by and large, we agree with that. But I think if you're going to quote Mr. Park, you ought to quote him accurately and not attempt to mislead or whatever. And so what I did was I went back to the transcript again, where Ms. Clark told you and showed you that photograph yesterday about whether or not Mr. Park saw or was looking at the Bronco or looking for the Bronco on the night of June 12th. Remember that? She told you yesterday I spent a long time with him. And so I remembered that I asked him questions and his response. I asked him at some point, I'm asking you if you looked to, made an effort to see if there was a car parked. Answer, no. Was that a correct answer at that time? Answer, yes. All right. Question. There might have been a car parked there and you didn't see it? Answer, correct. And the reason why you don't know one way or the other is because you weren't focusing on any cars or paying any attention. Isn't that right? And I went on to ask still another part of this question. Basically, your goal was to get Mr. O.J. Simpson, try to get him to the airport on time, isn't it? Answer, that's correct. Question, that is what you ended up doing, isn't it, sir? Answer, yes. Now, that's the testimony. So it's fine to come up here and tell you, because they want to fit their theory, that, well, he didn't see that Bronco out there and do all this drama, but isn't it better to read the record if you want to be accurate, which I've just done for you? Now, isn't it reasonable to ask Mr. Park also, well, Mr. Park, if if you were around the premises there and you were up at Ashford and down at Rockingham, did you ever hear a Bronco come driving up? Did you ever hear a door slam? Did you ever hear an engine of a Bronco? And fortunately, we asked him some of those questions. I'd asked him about seeing a Bronco in the past, and remember he talked about seeing one back in '88 or something of that nature. And so then I asked him this question. And would I be correct in assuming that those engines can be loud on occasion, those cars, meaning the Broncos? Answer, could be. Question, you didn't hear the engines on any cars or anything that sounded like a Ford Bronco that night, did you? Answer, no. Now, again, I've read from the transcript for you. I previously read to you about where Mr. Park said he saw Mr. Simpson in the entranceway of the house. We'll put that aside. So we know that Mr. O.J. Simpson was preparing to leave for this trip that had been long planned. And when we summarize then the two timelines, it seems to me that their timeline is not even reasonable. It doesn't make any sense. It's a much less credible version than the testimony you've heard from our witnesses. Their version does in no way disprove the defense timeline. We don't have to even put that forward, but we did. There then must be a reasonable doubt. Consider everything that Mr. Simpson would have had to have done in a very short time under their timeline. He would have had to drive over to Bundy as they've described in this little limited time frame where there's not enough time. Kill two athletic people in a struggle that takes 5 to 15 minutes. Walk slowly from the scene. Return to the scene, supposedly looking for a missing hat and glove and poking around. Go back to this alley a second time. Drive more than 5 minutes to Rockingham, where nobody hears him or sees him. Either stop along the way to hide these bloody clothes and knives, etc., or take them in the house with him, where they're still hoisted by their own petard, because there's no blood, there's no trace, there's no nothing. So that's why the prosecution has had to try and push back their timeline. Even to today, they're still pushing it back, because it doesn't make any sense, it doesn't fit. That's why they abandoned Ellen Aronson, why they abandoned Dan Mandel, why they didn't want to call Denise Pilnack, why they didn't want to call Robert Heidstrup. That's why we're now hearing this preposterous add-on of time that the thumps may have occurred at 10:15. That's Ms. Clark's wish list, but that's not the evidence in this case. Now let's turn our attention for a moment and let's look at some other things that don't fit in this case. So I started to say before, perhaps the single most defining moment in this trial was the day they thought they would conduct this experiment on these gloves. They had this big build-up with Mr. Rubin, who had been out of the business for 5, 6, 7, 8 years. He'd been in marketing even when he was there. They were going to try to demonstrate to you that these were the killer's gloves and these gloves would fit Mr. Simpson. You don't need any photographs to understand this. I suppose that vision is indelibly imprinted in each and every one of your minds of how Mr. Simpson walked over here and stood before you and you saw 4 simple words. The gloves didn't fit. And all their strategies started changing after that. Rubin was called back here more than all their witnesses, 4 times altogether. Rubin testified more than the investigating officers in this case, because their case from that day forward was slipping away from them. And they knew it, and they could never, ever recapture it. We may all live to be 100 years old, and I hope we do. But you'll always remember that those gloves, when Darden asked him to try them on, didn't fit. They know they didn't fit. And no matter what they do, they can't make them fit. They can talk about latex gloves. Didn't make any difference. They could talk about shrinkage. But we did something even better, didn't we? We brought a man who won the Dondero Award, Dr. Herb McDonald, who did an experiment on these Aris-like gloves. They wanted to talk about liquid or blood shrinking them. You'll see it up there. And what did he say? They don't shrink. Put as much blood as you can on them. They don't shrink. It doesn't work. They have the power of the state. They could have done their own demonstration. They didn't, because you know he's right. So we went about and proved to you these things. We didn't just stand up here and speculate as to what might be. We called a leading witness who came in and passed that on for you. So you could see the overlays on there. They cannot explain that. They could have called witnesses, they didn't. We called the witness. Proved beyond any doubt those gloves don't shrink. The gloves didn't fit Mr. Simpson because he's not the killer. Now, then they will say, and Ms. Clark said the other day, well, gee, these gloves had been thawed and they've been frozen and they've been all those things. But remember Susan Brockbank? Those gloves were measured on June 21st, 1994. Those gloves are basically the same size now as they were June 21st. So that won't work. They come, they tell you all these things, but it won't work. And so if you looked at gloves, here's the overlay. And there's something else about these gloves that I want to take a minute and share with you before we talk about Mr. Rubin and his testimony. You saw these pictures of the gloves? We had a couple of pairs of Aris Light. And when you have gloves that don't fit, you can hardly do anything with them. Makes it very, very tough. I put on a pair of Aris Light gloves that are real tight. And you can see how tough it is to try to get these on my hands. But I put them on anyway here. It's the same kind of gloves that Dr. McDonald did his experiment with. So there'd be no mistake about the leather and all those things they like to talk about. It's hard to get on. Not as hard as Mr. Simpson, but they're hard to get along. The reason I want you to see these gloves, because they want to tell you that when you take off gloves, you take them off by this V portion. Remember this? Somebody testified. You don't take off gloves that way. One of the people's witnesses said that. You don't take them off that way. So we're asked to believe that in this tremendous struggle, that night in which Ron Goldman fought so valiantly, that somehow or other, in that struggle, somebody took these gloves. The way you pull gloves off, I have to tell you this, you pull them off like this. Even Rubin knew this. Pull them off like this. The gloves came off like this, not through any way like that. And so I think it's interesting when you look at these gloves and you look at what they're trying to have you believe. They talked a lot about in their rebuttal case about the glove pictures and the glove photographs. Remember that each of the glove photographs were taken, or pictures of Mr. Simpson, were taken in the winter. You know the evidence. Mr. Simpson was living in New York, generally from August through January when he's at football season, or working for NBC Sports. Generally in Southern California, you don't need or wear winter dress gloves in California. You don't go skiing in Aris Light gloves. And you remember that the police, in searching Mr. Simpson's house, remember Detective Lang? They searched O.J. Simpson's house for gloves, for shoes, for clothes. Found one brown glove. But I want you to look at it at some point, the brown glove that looks very similar to the brown gloves that Mr. Simpson. Objection?
Sustained.
One brown, what?
Outside
One brown glove? this glove was picked up on June 28th, but what I was saying was this glove came out of Simpson's house, and I asked you to look at this glove. You'll have this back in the jury room. Look at it compared to some of the gloves he wore that day, on the photographs. There were no Aris-like gloves in O.J. Simpson's house. That's the point. They took this one glove on June 28th. That's the point. And the point is, quite simply, Richard Rubin, let's put him in perspective. Bob Blasier questioned him. On his 4th trip here, we discovered a letter that he sent to the prosecution. This man had become a soldier in the prosecution's army. Wrote him a letter saying he wanted to come to their victory party. The problem with that letter was he wrote the letter before we'd ever had a chance to put on our case. That solidifies the rush to judgment, doesn't it? Because in America, you have a right to wait until you hear all the evidence. That's what makes this country great. People are not making up their minds at the beginning. You don't decide a baseball game or a football game at halftime. You wait until the end. That's what this judge tells you every day. Keep an open mind till you've heard everything. But Rubin wasn't going to do that. He was getting ready for the victory party. In his own letter that he wrote to them, and he asked further, send me your cards. I want Mr. Hodgman's card and Miss Clark's card. He'll build a memorial to himself on his wall. The number of times he'd come out here. You talk about people who want to be involved in this case, you stack him up to those other people who didn't want to be here. Richard Rubin is one of those people, and it goes to his bias. It goes to his interest. I'm telling you the facts. We told you about this letter. You've got to deal with that if you're going to be fair and impartial in this case. And then, as with all the prosecution's evidence, they're going to tell you that something is not like what it seems. They take a Bloomingdale's receipt in which there's no size or color or anything else on this receipt. And I find this particularly interesting because it's part and parcel of the prosecution's case, isn't it? The way they've done things in this case. Look at this receipt from Bloomingdale's, and this is in evidence. We have the number for the court. 372B, Your Honor. Now, this is this famous purchase in December of 1990, wasn't it? The lot number or the style number is 70268. That's what it says. It doesn't say anything about 70263. It's 2 items. It says $77. It's $77 is what it says for those 2 items. It doesn't say anything about $55. It says $77. And it doesn't say anything about color or size or anything of that nature. It doesn't say anything about any mufflers. But yet you've been treated and told, oh, these had to be